Mr. Beat presents Supreme Court Briefs.
Texas and Georgia. The 1960s. Texas sentences one man to death, and Georgia sentences two men to death for crimes involving rape and murder. The Texas defendant, Elmer Branch, who later was found to have low intelligence, broke into the home of a 65-year-old widow and raped her, holding his arm against her throat. As he left, Branch told the widow if she told anyone what had happened, he would come back and kill her. The first Georgia defendant, Peter, or it could be Petra, I suppose. Anyway, Peter Jackson, not that Peter Jackson. That's just, come on. Yeah. A 21-year-old broke into a home and held up scissors to a woman's neck, demanding money. After she found no money to give him, he raped her. The second Georgia defendant, Henry Furman, a 26-year-old with multiple mental illnesses, attempted to break into a home, and after he couldn't get in, shot through a closed door, killing one person inside. He later claimed that his gun accidentally misfired. So all three men awaited the death penalty. However, their lawyers argued that they didn't deserve the death penalty for their crimes and appealed their cases. But the Texas Court of Criminal Appeals and the Supreme Court of Georgia both upheld the death sentences of all three men. That said, the three cases did catch the attention of the Supreme Court, who combined them into one to see if they went against the Eighth Amendment of the Constitution. In particular, the clause that said there shall be no, quote, cruel and unusual punishments inflicted. Well, what the heck did that really mean? The court heard oral arguments for the cases on January 17th, 1972. The big question was, did sentencing these three men to death go against both the 8th and 14th Amendments? The court said yes, although it was a close one. In a 5-4 decision, the court announced on June 29th, 1972, that the death penalty in the cases of these three men was indeed cruel and unusual punishment and therefore went against the Constitution. That said, the five who said it went against the Constitution couldn't agree on exactly why. Basically, three of the justices, Potter Stewart, Byron White, and William Douglas, expressed concern with the apparent randomness with how the death sentences were carried out and called out how there was probably racial bias going on since the three men were African American and the victims were white. The other two justices, William Brennan and Thurgood Marshall, believed the death penalty was unconstitutional under any circumstances. Marshall wrote, quote, no matter how careful courts are, the possibility of perjured testimony, mistaken honest testimony, and human error remain too real. We have no way of judging how many innocent persons have been executed, but we can be certain that there were some, unquote. The four justices who dissented basically said the federal government would ultimately have a really difficult time classifying one punishment as cruel and unusual while permitting another. It could get too complicated really quickly. Regardless, this case known as Furman v. Georgia effectively placed a temporary ban on all future executions in the country until more guidance came from another court challenge. All of a sudden, 630 people on death row were not on death row anymore. Instead, they now face the rest of their lives in prison. In the meantime, 35 states wrote new death penalty laws to try to satisfy the Supreme Court's suggestions. 5 of those new death penalty laws are what ultimately got the Supreme Court back in the game of the issue. On November 21st, 1973, a dude named Troy Gregg and his friend, Floyd Allen, were hitchhiking in Florida. Two men named Fred Simmons and Bob Moore picked them up and drove them up to Atlanta, Georgia. Aw, that was really nice of them. But Gregg murdered them anyway in an attempt to rob them. Later, Georgia charged him with first-degree murder and armed robbery. Now, Georgia was one of those states that had passed a new law after the Furman decision. While Gregg was found guilty of first-degree murder and armed robbery, there was still confusion about his sentencing. He actually got 2 2 trials, one to determine guilt and one for sentencing. At the second trial, the jury found the death penalty acceptable since they didn't think it went against the Eighth Amendment. Basically, it was more clear-cut that Gregg deserved it. Well, Gregg didn't think he deserved it and appealed to the Georgia Supreme Court, but it agreed with the lower court, so he appealed again to the United States Supreme Court, who agreed to hear oral arguments on March 30th and 31st, 1976. The court decided to combine this case with 4 other cases, since similar laws were passed in Florida, Texas, North Carolina, and Louisiana after the Furman decision as well. Together, these cases became known as the death penalty cases. The court found themselves once again attempting to answer the same basic question: was the death sentence okay in these 5 cases, or did it go against both the 8th and 14th Amendments? This time, the court said no. On July 2nd, 1976, almost exactly 4 years after the Furman decision, they announced they had sided with Georgia and the other states. Basically, they said the death penalty didn't go against the 8th Amendment and 14th Amendment under all circumstances. In some extreme criminal cases, like when someone deliberately kills someone else, the death penalty may be okay if there's good judgment that's carefully carried out and stuff. It's worth stressing that 8 of the 9 justices this time were also there for the Furman decision. Yet this time it was 7-2, more definitive. The only 2 who dissented were the 2 I mentioned before, Brennan and Marshall. Remember, who believed the death penalty was unconstitutional under any circumstances. The court established 2 broad guidelines that state legislatures had to follow to make sure they didn't pass sentencing laws that went against the 8th Amendment. Number 1, they had to provide objective criteria in order to limit how many death sentences are carried out. And number 2, they had to allow the judge or jury to take into account both the character and record of an individual defendant. In establishing these 2 guidelines, the court hoped to also resolve the issues of the cases in the Furman decision. Regardless, Gregg v. Georgia once again said that the death penalty was okay in the United States. However, the death penalty has been controversial ever since. Executions resumed in 1977, and since then, more than 7,800 defendants have been sentenced to death, and of those, more than 1,500 have been executed. Currently, more than 2,500 convicts are on death row. Speaking of which, Tony Gregg was sentenced to death. However, on July 28, 1980, while on death row, Gregg escaped the Georgia State Prison with 3 other condemned murderers. It was the first and only death row breakout in Georgia history, and they did it by changing their prison clothing to look like prison guards. However, Gregg was murdered later that night at a biker bar, and his body was dumped in a river. I'll see you for the next Supreme Court case, jury. So what is your opinion about the death penalty? Let me know down below. Also, I chose these cases based on the suggestions of my Patreon supporters and viewers like you. So what other Supreme Court case suggestions do you got? And finally, next Friday is a video that I am really excited about. I've been planning it for a very long time. I tell you what, just go ahead and leave your browser open to my channel page so you don't miss it, okay? Just leave it open.